Hello, dear people. I hope you have been well. Today we are going to tackle the topic of intestate succession. Under intestate succession, there are some queries people always have, and in this very video, we are going to deal with them. My name is Fiona. I am a lawyer. I work with Sasser and Company Advocates, and here we go. Intestate succession refers to a situation where a person dies without making a valid will, and as such, their property or estate must be shared according to the Succession Act. An intestate is a person who dies without making a will. Letters of administration is a document issued by court that empowers a person to manage an intestate's estate, or a person who died without making a will's estate. The surviving spouses or spouse has priority over any other person in the administration of an estate of an intestate person. However, courts have the power or the discretion to disregard a surviving spouse if it can be proved that the said surviving spouse is an unfit and proper person. An administrator is a person to whom letters of administration are granted to manage an estate of a deceased person or an intestate. Under Intestate Succession, Succession Act lists the beneficiaries thereunder, and these are surviving spouses, dependent relatives, lineal descendants, customary heir or heiress, and closest relatives, who only, the last category, which is the closest relatives, only will have a share in the deceased estate in the absence of the first four. According to the Succession Act as amended, the distribution of an intestate's property or estate is as here under. The spouse is entitled to 20%. The dependent relatives are entitled to 4%. Lineal descendants, and this is where children, grandchildren, great-grandchildren fall, are entitled to 75%, as while the customary heir is only entitled to 1%. However, where there is no surviving spouse or dependent relative, but there are surviving lineal descendants and an heir, the lineal descendants shall receive 99%, while the customary heir receives 1%. In another situation where the deceased is survived only by a spouse and dependent relatives and a customary heir, but there is no lineal descendant, the spouse takes 50%, the relatives take 49%, and we are talking about dependent relatives, while the customary heir or heiress is entitled to 1%. Where the deceased is survived only by a customary heir or heiress and a spouse, the spouse gets 99%, while the customary heir gets 1%. Where the deceased is survived only by a customary heir and a dependent relative, the dependent relatives get 99%, and the customary heir or heiress only gets 1%. That's all for today. I hope that this has been helpful. If you have time, go and read the Succession Act amendment, and you'll be surprised at the new developments the law has introduced, and we shall all be informed together. Thank you so much for watching. I hope that this information has been of benefit to you. Share this information, share this link with someone who may as well benefit. Information is power. Subscribe, like, leave us a comment, and we hope that you can come back to our channel and give us your time and watch more of this kind of content. Bye.